Good morning, good evening, wherever you are in the world. Thank you very much for joining us on this roundtable workshop, Human Rights-Based Climate Litigation, Development at the National, Regional and International levels. It is a pleasure for me to introduce you to the chairs for today, Dr. Caio Borges, he's from the Law and Climate Portfolio Coordinator at CICS, and Dr. Maria Antonia Tigre from the Sabin Center for Climate Change at the University of Columbia. Thank you very much.
Thank you very much, and hello to everyone. It's a pleasure to co-chair this session on human rights-based climate litigation developments at the national, regional, and international level. I would like to also thank my co-chair, Maria Antonia Tigre, and also to welcome my fellow panelists here, Justice Barroso, Lucy Maxwell, Natalia Gavaz, Sophie, I don't know if had joined yet, and Cesar Garaveto, who is also joining us. So we will have more people here with us to discuss this issue. I would like just to introduce very quickly the topic, the subject, and then after me, Maria Antonia will also make some very brief initial remarks and also introduce you to our speakers. We have chosen this topic because it has amongst inside the universe and the myriad of hot topics within climate litigation, human rights-based climate cases have been drawing international attention because there have been some really interesting developments at different levels. And we can see from some landmark cases that courts have been making really interesting interpretations of human rights and constitutional law to extract from these norms the obligations of states and corporations to mitigate and adapt to climate change. I would just mention how courts interpreted 3 cases to illustrate how this is a diverse, but also evolving phenomenon. When the Render case, the Dutch court said that human rights was an important factor in assessing the duty of care owned by the Dutch state towards its citizens. Then we had the Neubauer case by the German Constitutional Court, in which the German court found that the state has an obligation to protect the individual liberties of the future generation. And this was also a landmark ruling by the German Constitutional Court. And more recently, in a case where the Supreme Court of Brazil decided a case about the climate fund, the Supreme Court ruled that the Paris Agreement for the Brazilian constitutional system is a human rights treaty. So this is just to illustrate how different courts around the world are interpreting human rights law. And then from that, these courts are either tackling state inaction or also compelling the government to review their current climate policies so as to be more ambitious and aligned to the Paris Agreement. So this panel is for us to discuss some of these developments, not only at domestic courts, but also in international mechanisms. So thank you very much. And I hope you enjoy our panel and our discussion.
Thank you so much, Caio. So just very briefly, and on behalf of the Sabin Center, just wanted to thank you, all of you, for being here. It's really a big pleasure to share this panel with all of you and co-host this with Caio. And really what we're trying to do here broadly is trying to understand the rights-based human rights cases from an international, a regional, and a national perspective. So we're going to shift a little bit from the broad international level, and then focusing specifically on Brazil, as well as one of the key examples here of what climate litigation can do from a human rights angle. So I'll basically introduce all of you right now, so then you can just jump in whenever the other one finishes. I think it sort of flows a little bit better. But we're gonna start with Cesar Rodriguez Garavito, who is a professor of clinical law and faculty director and chair of the Center for Human Rights and Global Justice at NYU. and the founding director of Climate Litigation Accelerator. So Cesar is going to talk a little bit about the victories and challenges in human rights-based climate litigation. Then we're going to move to Lucy Maxwell, who is the co-director of the Climate Litigation Network, a project of the Agenda Foundation, and she's going to talk about key legal issues in human rights-based climate cases and how plaintiffs in courts and human rights bodies have addressed them. Then we're going to hear from Justice Luis Roberto Barroso at the Brazilian Supreme Court. He's going to talk specifically about this case that Caio mentioned and how the Paris Agreement has been recognized as a human rights treaty in the Brazilian Climate Fund case. And then Sophie Marhanak, who is the leader of the Climate Accountability Initiative, is going to go next if she joins us. And then Natalia Kobilaris, who's the senior lawyer and environmental coordinator at the at the Registry of the European Court of Human Rights, is going to talk about the cases in international human rights body at the European Court of Human Rights. So Cesar, I'm going to lead to you now, and thank you again, and hope everyone enjoys the conversation.
Thank you, Antonia and Caio, and hello everyone. Apologies for the poor connectivity, but connectivity at COP has been a challenge. But I hope that you can still see me. What I'm not going to be able to do is share my screen and slides, because that would risk dropping the connection altogether. But I'm really glad to be part of this distinguished panel with dear colleagues and friends of a really vibrant, no longer emerging, but stable and thriving subfield of adjudication and litigation. The brief comments that I'm going to offer today are based on a book that just came out. Actually, today is the day where it'll be up on the web, on Cambridge University Press's website for free and open access. It's called Litigating the Climate Emergency, and it offers an overview of rights-based climate litigation. So I want to be explicit about the kind of the contours of the universe, which jive with those of this panel, which is that I'm not looking at the whole universe of climate litigation, only looking at rights-based climate litigation. And once we focus on that, and CLX, the program that I lead at NYU, keeps a running tab of those cases, but not in the way that the Sabin Center does it, which of course has been doing very competently for many years now. But we go into the details of those rulings and right case studies, and through that work, we have been able to extract a few lessons that I'm going to distill for you in the terms that were proposed in the helpful introductions by Caio and Antonia, meaning what the victories are and what the challenges are. So let's start with the victories. First of all, the sheer quantity of cases and the outcomes of those cases, I think, should be deemed as a victory. I was a lead litigant, co-counsel in one of the early cases in this wave of rights-based climate litigation, what some authors have called the rights turn in climate litigation. And that case was filed in 2017 in Colombia. Eventually made it all the way to the Supreme Court of Colombia, and was won on behalf of 25 people who sued the Colombian government for lack of action against deforestation. Back then, I remember talking to colleagues both in Colombia and around the world, and there was a lot of skepticism, both about the prospects for success and some key issues that I know Lucy is gonna delve deeper into, like, well, do petitioners, plaintiffs who are not located, say, in the Amazon region, can they sue for damages that happen in their own territories in other places of Colombia? Now, that question has been solved, answered in the affirmative in most cases. And we're even looking at cases that are being filed by nationals of a given jurisdiction, say Peru, against a corporation based in completely different jurisdiction, like Germany, like in the RWA case. So First victory is quantity. There's more than 200 rights-based climate cases filed before national, regional, and international judicial and quasi-judicial bodies. Second, the doctrine and jurisprudence on the issue has changed very rapidly. In a matter of 5 years, we've been able, and by we, I mean the climate litigation field, has been able to turn around some of these questions and fill with content some of the answers, some of those henceforth complicated legal issues. Third, in terms of actual outcomes, in our count, of course, most cases are still pending because they're relatively young cases, been filed mostly over the last 5 years or so. So 2/3 of cases are still pending, but out of those that have been resolved by courts, there's pretty much a tie between those going for the plaintiffs and those going for governments and corporations, which again, for a young field, is a surprisingly positive development. And finally, the last victory that I would highlight is more socio-legal as opposed to legal in nature, is that the impact, and we're looking at the impact of some of these cases, has gone above and beyond the actual orders of the court. So in an old article that I wrote about the impact of courts' interventions on socioeconomic rights about 10 years ago, I classified the impacts of rulings between direct and indirect impacts on the one hand and material and symbolic impacts on the other hand. So we usually take a look at whether or not the court's orders are complied with by the government or by the corporation that's targeted by the lawsuit. And that's, of course, an important issue to assess and determine. But as we know, from a socio-legal point of view, litigation and court interventions in these complex policy fields, the impacts go well beyond those direct orders. And some of the indirect effects that I would highlight is litigation has helped set the agenda on the urgency and the scale of the problem of climate action. B, it's catalyzed social movements that may be even more consequential in bringing about real change on climate action, in a much deeper and long-lasting way than courts and lawyers can will ever do. And finally, there is the issue of the impact on negotiations. One of the arguments that I make in the book is that unlike the view of some scholars and practitioners, I do not necessarily view litigation and negotiations as being in a zero-sum game relationship with each other. So even negotiators that we've interviewed acknowledge that the pressure coming from the bottom up and from courts for governments to actually deliver on their lofty promises in places like Sharm El Sheikh here or Paris in 2015, that pressure has helped those who want to do more about climate action to say, well, it's not me, it's the courts asking me to do more about climate action. I'll end with a word on challenges. Of course, the first thing that I want to give is a note of caution. So climate change is the existential planetary challenge, and it won't be solved on a case-by-case basis. The solution, of course, needs to involve collective global action or a multitude. As I actually think that if anyone has read this fantastic science fiction book on climate change called The Ministry for the Future by Kim Stanley Robinson, one of the beautiful things about that book is that it helps us envisage a future in which the climate problem is quote unquote solved, not by a master plan of being hashed out in Egypt or in any COP or in any capital, Washington or Geneva or London, but it's the net result of a multitude of actions by all kinds of actors, by youth activists, by governments, by corporations, by religious movements that embrace environmentalism and so on. And I believe that even if climate action has indeed provided some impetus in the positive direction, of course, we want ultimately achieve the scale or the speed that is needed to address the climate solutions. So with that said, I won't have time to elaborate on any of these challenges. I'll just list them and end with that. First challenge is the overwhelming and disproportionate focus on mitigation as opposed to adaptation and loss and damage. So just as the climate negotiation agenda has focused mostly on adaptation for good reasons, but also for geopolitical reasons, there hasn't been enough attention being put on the problems that actually affect most the global south, which are adaptation to the already inevitable impacts of climate change, and the emerging issue here at COP and in Glasgow, the reparations, loss and damage. So that's the frontier of climate litigation that I see some courts and some litigants already working on. We certainly at NYU Climate Litigation Accelerator were quite busy developing strategies on loss and damage litigation, but there so are many other organizations and programs. Second challenge, the disproportionate focus on governments as opposed to corporations. In our database, 92% of cases have been filed against governments as opposed to corporations. And yet we know that companies from fossil fuel companies to the JBSs of the world are responsible for a large amount of carbon emissions that they're not truthfully reporting and that they are kind of incorporating into the business models in ways that are not sustainable in the medium and long term. So cases like the Shell case last year before the Dutch High Court are, I think, at the frontier, also at the frontier of the new wave of climate litigation. And finally, in terms of challenges, there is still a geographic and regional divide and asymmetry. Up to 60% of cases have been filed and decided in Europe for, this explains partly the focus on mitigation. But on the more encouraging note, to end on that note, countries like Brazil or in courts like the Inter-American Court of Human Rights and also human rights commissions like the Filipino Human Rights Commission are already making considerable progress towards laying out the doctrines and actually putting together the remedies that are necessary for governments and corporations to be accountable for doing more about climate action. So I anticipate that this field is going to get much more even as fantastic organization activists and courts in places like Brazil continue to be even more proactive on this front. Thank you.
Would you like me to start, Maria Antonia? Fantastic. Okay. Thanks a lot, Cesar. It's great to be with everyone. My name is Lucy Maxwell, and I'm the co-director of the Climate Litigation Network, which is a project of the Agenda Foundation. We support communities to bring litigation against their national governments to ramp up their mitigation ambition, based on that original landmark climate case that the Agenda Foundation won against the Dutch government. And many of these cases are based on states' human rights obligations. These cases that I'm going to be talking about today and that we support challenge a government's overall mitigation efforts in light of best available science. So they're different from climate cases that challenge individual fossil fuel projects like coal mines or offshore oil and gas. And because of this focus, these cases have the potential to result in whole of government climate policy changes and to galvanize huge public mobilization on what the government is doing. For this reason, they're called systemic or framework cases. And just touching on what Cesar has indicated in terms of trends in rights-based litigation in general, indeed, the cases I'm talking about do sit within that focus that Cesar has said is common, so that they're mitigation focused they're against governments, and a lot of these are in the global north. And the reason for that focus is because of a climate justice agenda. It's because these cases are focused on mitigation as the primary preventative tool we have to prevent further climate harms. And they're targeting the governments that are most responsible because of historic emissions. And they're focusing on governments because of government's regulatory power. So those choices are informed by a very strong climate justice agenda that we hope brings benefits to all affected communities around the world, global south and global north. So just to explain a bit about that focus on mitigation, governments, and governments in the global north, which are a lot of what the cases I'm going to be talking about, underpinned by a climate justice position, which I'm very happy to talk more about. So in this presentation, I'm going to focus on 5 trends in these cases, focusing on national level decisions. And I'll be drawing on our experience working on dozens of these cases around the world and a new report from the London School of Economics and Political Science, the LSE, on government framework cases. Many of these cases are based on human rights obligations of governments, but not all of them. So my comments will extend beyond just rights-based cases. The first thing to note about these cases is how many there are. We've heard, Cesar's indicated, this huge growth in rights-based cases in general, and framework cases that challenge government's overall mitigation efforts are following that trend. So since 2013, when the Dutch agenda case was filed, the LSE report indicates there are now 80 of these cases against governments at the subnational level, national, regional, and international level. And that's 80 cases before courts and human rights bodies, tribunals, etc. And the IPCC in its 6th assessment report recognized that the agenda case in the Netherlands and the Ligari case in Pakistan, both issued judgments in 2015, had sparked this wave of litigation around the world. And that's certainly what we've seen. If we look at the framework cases against the richest governments at the national level, there are about 30 of those cases. And about 1/3 of them are still pending. So a final decision hasn't been issued. So we can see that there's very much an emerging area in which trends are still being developed. The second point I wanted to touch on is the success rate of these framework cases against governments. 9 of these cases have gone to the highest court in a country. And of those, 7 have been successful, according to LSE's report. So that's about a 75% plus success rate. On that basis, the LSE report concluded, and I quote, that government entities at all levels should anticipate the emergence of legal duties to act on climate change and develop internal decision-making processes consistent with avoiding harmful impacts from climate change. So that's a very important building block, that success rate at the highest court level in these cases. The third thing I wanted to touch on is, what are the legal developments that national courts are doing when they're adjudicating these cases? I'll really just briefly touch on some of those developments, but we published a synthesis of those developments earlier this year, which I'm very happy to share, which goes into more detail. The first thing we see from national courts adjudicating these cases is that the separation of powers doctrine and questions around justiciability has not been a barrier in many of these cases. There are some exceptions in North America in which separation of powers has proven to be a barrier, but in many other jurisdictions, this has not prevented national courts from finding that framework cases against governments are justiciable. This includes courts in the Netherlands, Ireland, Germany, Belgium, Canada in the Mather case, Colombia, France, and Nepal. In all of those cases, courts have found it appropriate to go on and adjudicate whether the state is indeed taking reasonable and appropriate measures, often pursuant to a tort or a human rights duty, to mitigate climate change through emissions reduction measures. The other thing we see in these national court decisions is that many national courts have found that the state's existing obligations to protect rights to life, to private and family life, to health, the right to a healthy environment, or their general duties under tort law apply to the problem of climate change. That's been another important legal development. Finally, we see that national courts in adjudicating these cases have not found the question of causation to be a barrier to adjudication. Many national governments, when they're defending these cases, make arguments along the lines that the individual contribution of their country to climate change is not globally significant, so there should be no legal responsibility. No national court has accepted this line of argument during the merits proceedings. We know that in 2021, there were a number of key breakthroughs in decisions by courts in these framework cases against governments. They're decisions by the highest courts in Germany and France and in Belgium. And these were very significant decisions that have received quite a lot of attention already in these kind of dialogues and webinars. So what have we seen in 2022 in framework cases against governments? Some of you may be aware of the decision of the Prague Municipal Court in the Czech climate case. That's just another instance of a national court, again, this time in Europe, indicating that the existing legal framework there on the right to a healthy environment can apply to the question of climate change. And indeed, in that case, that there was a violation because the state was not doing enough to mitigate climate change. Another important development in 2022 was that the Mather case in Ontario in Canada went to trial. That's very significant because it's in a common law jurisdiction in which in some instances it's been harder to see a case like this progress to trial. So that will be very interesting to see what the developments are in that case. Similarly, the Australian tort-based framework case against the Commonwealth government is also proceeding to trial, and there's no strikeout proceeding there. We did see some unsuccessful decisions in New Zealand and Canada, but that fills out the picture of really what's happened this year in 2022. The last two things I wanted to talk about were the impact of these cases when they are successful and what implementation means. Very briefly, and for those who are interested, I'd recommend looking at the findings of AR6, the third working group on the impact of climate litigation. Some very interesting findings based on academic literature tracking the impact, including, and I quote, that it has influenced the outcome and ambition of climate governance, which is very helpful to see. The LAC report also documents, as Cesar said, both direct and indirect impacts of framework cases. Direct impacts being in the Netherlands and Germany, immediate changes to the climate law framework, increases in the emissions reduction targets, caps on coal-fired power production. And then the indirect impacts being things like widespread public mobilization that follows these cases. In France, 2.2 million people signing a petition in relation to the climate case. In Ireland, hundreds of thousands of people being motivated to join the climate justice movement. But implementation of court judgments when they are successful remains very important. And I'll end on that point, which is just to say, the field is maturing. We're seeing successful judgments in courts, not in every case, but in a number of those cases. And what then the focus has to be in countries where there has been a successful outcome in court is implementation. And in the Netherlands, the Agenda Foundation consistently worked on implementation strategies for a long time from that first successful court decision in 2015. And in the French and German cases, this year sees a deadline for implementation of their court orders. So civil society is really mobilizing around that to ensure that the wins in court result in real world emissions reductions. And so I think I would end on that note that implementation is going to be key as we start to see more and more wins in court. So thanks a lot and look forward to the question and answer.
Wonderful, thank you, Lucy. Justice Barroso, do you want to go next?
Yes, sure, my pleasure. I greet everyone, Caio and Maria Antonia, for hosting this panel and all the participants that have made beautiful talks. And I'll try to briefly describe how I see this matter from my point of observation. Well, the way I see it, human rights correspond to a minimum reserve of justice to which all people are entitled. And they include the rights to freedom, equality, and also the right to the existential minimum, to the vital minimum. This existential minimum includes rights related to a minimum income, to basic education, and access to health care. There is a growing perception, however, that the right to a healthy environment is also a fundamental right inherent to the existential minimum. To be true, the way we deal with this matter in Brazil, it always involves a human rights or a fundamental rights question, because the Brazilian Constitution states that an ecologically balanced environment is a fundamental right, and there is a duty of the government to protect it. So for us, claims involving environmental rights naturally has the status of litigating fundamental rights. And I tend to think that this is a trend that is now developing around the world. Caio mentioned at the outset the Neubauer case in Germany, in which fundamental rights was the basic ground for the decision. It was actually the first case that I know of dealing with the issue of intergenerational equity, recognizing that the existing law left too much burden to future generations for lacking sufficient specification for the reduction of greenhouse gas emissions beyond 2030. That was a fascinating decision, I think. And as we all know, there is now a case pending before the European Court of Justice. Well, you know, these things disappear when you need them. It's the Agostinho case, if I'm not wrong. And there is also a recent decision by the UN Committee on Human Rights, also acknowledging that the climate litigation involving the Torres Strait is related to a human rights question. So I think this is a very important trend that we are now all watching throughout the world. Well, in Brazil, we had this very important case, a landmark case that was decided last July, and I will briefly describe what was decided because for Brazil, it was very important. And I was listening to Lucy, and she mentioned that most cases did not reach the higher court in the original countries. Well, in Brazil, it occurs just the opposite. As some of you might know, in Brazil, there is what is called a direct action. So you can file a lawsuit questioning a statute or, in some cases, a public policy directly before the Supreme Court. And all political parties have standing to do that. So most important issues in Brazil are at a certain point, and quite often at the starting point, litigated before the Supreme Court. The Supreme Court in Brazil has a very powerful protagonism, I think I could say, in many matters. What actually has made it a target of authoritarian populism, as you might have heard, the attacks against the court more recently. So this case, that's called the Climate Fund case, it was actually filed before the Supreme Court by 4 political parties. In this claim, they mostly argued the following. The Climate Fund was created by law with the purpose of securing resources for initiatives here to fund. Okay, let me restart. This was a direct action filed by 4 political parties before the Federal Supreme Court on the grounds that the federal government kept this climate fund inoperative in 2019 and 2020. And the claim was for, one, the recognition that the government has a legal duty to tackle climate change. Second, the resumption of operation of the fund. And third, the prohibition of budget impounding of its resources, meaning the government could not withhold such monies to make a primary superavit. The climate fund main source of funding came from special participations in oil exploration, and as well as domestic and international donation. So this is the picture. And they added, Brazil had made a voluntary commitment to reduce greenhouse gas emissions between 36 to 38% in relation to a projected emission for the period by 2020. Although such commitment constituted a mere political declaration with no binding character, the announced goal was internalized, was confirmed in a statute that established the national policy on climate change. And the commitment implied the reduction of the annual deforestation rate to a maximum level of approximately 4,000 square kilometers. So there was a fund whose purpose was to fight climate change. Brazil had an international commitment to reduce emissions and to reduce this deforestation, and the plaintiffs were able to demonstrate that Brazil was not complying with these commitments, and this commitment, in the case of Brazil, was internalized by a domestic statute, making it a binding obligation. So the opinion that the court took by 10-1 was the following. First, it made the important statement that treaties on environmental law constitute human rights treaties, and that therefore, in line with the understanding of the Supreme Court, they have a supralegal status. That is, they are below the Constitution, but they are above ordinary law. That means that an ordinary law, and much less an executive order, can contravene the treaty. And the final court decision, dated July 4th, 2022, recognized, one, that the protection of the environment and the fight against climate change do not constitute a political issue, but rather a constitutional and legal duty of the federal government. That was a very important decision because, as you all know, in most cases in the world, although this is a changing trend, but in most cases in the world, courts will say that that's a political question, or they will say that plaintiffs do not have standing. So I think this is a barrier that we were able to overcome in Brazil. And it probably was easier to do in Brazil because the Constitution, as I said before, states that environmental protection is a fundamental right, and there is a duty by the government to protect it. So these two statements are very important. The Paris Agreement is an international human rights treaty. That was the first thing. The second, the issues involving climate change and environmental matters are justiciable, can be discussed by courts. And then in the specific case, the court ordered or decided that the government cannot abstain from the operationalization of the fund, meaning it's not discretionary, since there is an international, constitutional, and legal obligation. It's not discretionary for the government to make the fund function or not. And last but not least, the government cannot withhold its funds, nor give it a destiny different than the ones provided for in the legislation that created the fund. That was the first case litigated in Brazil. I'm coming to an end here. There is a second case, very much alike, that was decided last week, involving the Amazon Fund. And in that case, along the same lines, the court decided that the decision that the government took by eliminating the main counsels responsible for the governance of the fund was unconstitutional. And that decision of abolishing these two committees that were responsible for the governance made Norway and Germany interrupt donations to the fund. So the court voided the decrees that changed this governance and ordered the government to resume its regular operation. And there is a third and last lawsuit before the Supreme Court, a very interesting one, fascinating case, because in that case, by showing that the federal government policies went against the Constitution, against the international treaties, by dismantling the agencies responsible for controlling climate, the decision of not protecting the Indian reserves, and several other decisions, created a unconstitutional state of affairs regarding climate in Brazil. And thus, what the request to the court is to order the government to either resume a plan for the Amazon, basically, that involved control and command actions, or to present a new plan. So it was a structural litigation. The rapporteur voted granting the order. So we would have a court order for the government to present a comprehensive plan of tackling climate change and other environmental matters. But what happened in that case is that one of the justices asked for halting the discussions so that he could study it further. It's a possibility that there is in the Brazilian Constitutional Court that one of the justices may stay the judgment for further studying the case. So we only have one vote in that case. So this is the scenario, I would say, in Brazil. It's interesting that litigation is happening mostly, or very importantly, before the Supreme Court. The Supreme Court has been very progressive, I would say, and I'm happy about it, in granting orders for protecting the environment and tackling climate change. I think this is, in short, what I could say about Brazil. Thank you very much for inviting me.
Thank you very much, Justice Barroso. It's really interesting to hear this overview of the cases at the Brazilian Supreme Court. All right, Natalia, maybe you can go next.
Yes, sure. Thank you very much. It's a pleasure to share this panel with all the esteemed speakers. My name is Natalia Kobylasz, and I am a senior lawyer and the environment coordinator at the Registry of the European Court of Human Rights in Strasbourg. So I was asked to present to you the cases that are pending before the court. Obviously, I'm not going to be able to provide you with a comment because all of these cases are still pending. And wherever necessary, I will also make a reference to the cases that were deciding, the applications that were already decided before other human rights bodies. So if I may, I will quickly share my screen with you, and if the connection is weak, I will simply switch off my camera, if you permit. Hang on, just a sec. Okay, can you see it all right? Okay, good. So let me take you through a quick inventory of these cases. The first one was already mentioned by Justice Barroso. So it's Duarte Agostinho and others against Portugal and 32 other states. This is an interesting case because it was brought against 33 member states. So you will see later on what kind of questions and human rights issues this case raises. In particular, the case was brought, as you can see in the picture, by a group of youth and young adults. The second case was brought by older people, by the Association of Clima Seniorinnen and others against Switzerland. So the average age of these applicants, it's more than 70. Then we had a case brought by an individual, Mr. Carême, against France. Mr. Carême, you might have heard of him because he was one of the applicants in the Grande-Sainte case. He was at that time the mayor of the village or the city of Grande-Sainte. And what happened to him is that despite the fact that this case of Grande-Sainte went all the way to the highest administrative court in France, the individual application of this gentleman was stopped because of the lack of legal standing. So he is coming to the European Court now to challenge that decision. And then we had a case in the meantime brought by Greenpeace Nordic and others. So this is a follow-up to the unfavorable decision that they received in Norway, complaining about the issuing of licenses to explore the Barents Sea for possible future oil exploration. And then, then we had a case brought by a person who is ill, and his medical condition makes him more handicapped, or makes him physically he has to use a wheelchair with the rise of temperature. So this is an interesting case against Austria. Milner, this case is referred to widely as Mex against Austria. We named it Milner because of the name of the applicant, and this is an interesting case because the applicant is already suffering, he claims, the effects of the heat waves. Then we had a case against 12 states, more recently brought, Subesta and others against Austria and 11 other states. And this case is interesting because it concerns the Energy Charter Treaty, which everyone now talks about, as the European countries are now signing out of that treaty. And then the brand new case received just in September, Engels, we named it Engels and others against Germany, and this is the follow-up to Neubauer. So this is interesting because everyone here in the panel and through all the academic articles and panels praises the decision of the Constitutional Court of Karlsruhe for its innovative approach and its adamant stance on the compliance, or rather non-compliance with climate goals by Germany. But here the applicants are still challenging the aftermath and the implementation precisely of that judgment. They are coming to the European Court of Human Rights to claim that the Climate Protection Act, which now has been amended following the Neubauer judgment, is still not sufficient, and the targets in that act are insufficient to really meet the ambition and the goals following up, stemming from Paris Agreement. We have, in addition to these 7 cases, we have 5 other applications, 1 against Norway, 2 against Italy, and 2 against the UK. They are more minor cases, but they are still concerning, like all of these cases that I just presented to you, the mitigation, or the allegation is that each of those governments is not meeting the targets stemming from their nationally determined contributions, and that in general the trajectory of these states is insufficient. And obviously with the Energy Charter Treaty, this challenges the whole policy that the energy transition cannot happen really if the countries are bound by the commitments of the Energy Charter Treaty. These cases started coming to the European Court in September 2 years ago, 2020. And then, as you can see from these dates, they still keep on coming. So in the summer, we received 2 or 3 of these cases, 3 cases, and then just in the month of September, the post-Neubauer case. And then the court has given priority to some of these cases and communicated 3 of them very quickly. So the Portuguese children case, the Swiss senior ladies, and the Norwegian case, they were quickly communicated to the parties. That meant that the court triggered the procedure to then examine these cases on the admissibility and on the merits. And what happened then is that because the court has realized that these cases were of a particular importance and particular complexity, 3 of them, so the Duarte, Clima Signorinen, and Carême, together went to a grand chamber by means of a relinquishment. So relinquishment is a particular procedure when the judges of each composition of the chamber can relinquish their jurisdiction to the benefit of to the jurisdiction of 17 judges of the grand chamber. So this procedure has now been triggered. The questions have been communicated to the parties. I'm not really allowed to comment on the content, but if you are representing parties, so I mean, these are all part of strategic litigation, so it's easy to find information, more details about these cases on the internet, really. So the hearing, there will be, as in all grand chamber cases, there will be a hearing. We will see if the hearing is going to be in all the 3 cases. I mean, it is possible still that one of these cases will go first, the others will wait. We don't know at this point how the court is going to approach it. For the time being, all the parties in all 3 cases were asked to make submissions, and in the spring of next year, there will be at least 1 hearing, if not 3 hearings. As the practice goes, the other cases then have been adjourned or are in the process of being adjourned. That means that if a case raises a similar issue that is now pending before the grand chamber, the court waits and does not decide this case. So the Norwegian case, which had been communicated earlier, has also been adjourned, awaiting the decisions of the grand chamber in the 3 main cases. And now let me just quickly take you through the issues that these cases raise. First of all, I mentioned that they were relinquished to the grand chamber. 3 of them were relinquished to the grand chamber. Well, that already points to the complexity of these cases, and under Article 43 of the European Convention on Human Rights, there are some formal requirements that actually a case that goes to a grand chamber potentially raises questions that affect interpretation or application of the convention and or serious issues of general importance. So that may mean that the judges of the chamber that relinquished the cases considered that the cases raised new issues not yet decided by the court or of importance to the development of the court's case law, and then also of importance, to the governments, affecting potentially the policy and the law of the governments. Now, having said that, it may still happen that the judges of the grand chamber will decide, no, actually, they are new factual issues, but in fact, we already have enough case law, and we are going to stick to the general principles that we have now, and we're going to decide these cases in a sufficient manner on the basis of what we already have. So at the end of the day, we still don't know whether the grand chamber is going to really indeed stick to the principles that exist, if they are going to stretch those principles or redefine them or realign them in order to match the circumstances presented by these cases, or if they are going to come up with completely new general principles that will be fit for this context. So watch this space. This is all I can say. Now, factually, I here focus only on the 4 cases that one way or the other were communicated. So as you can see from this table, obviously, there is a question of both direct and potential victim. So potential victim is across all these cases. That means that the applicants are complaining about the future risk of future impairment, future interference with human rights. 2 cases, the Portuguese children and the senior women from Switzerland, they are also complaining about the current affectation. So currently they're complaining about wildfires, droughts, heat waves, And then for the future, Mr. Karen, rising sea levels, which may endanger the home in which he is living. Obviously, the Duarte, the Portuguese children case, raises an issue of exhaustion of domestic remedies because these applicants did not go before any of the 33 domestic courts to bring their complaints. So we will see, obviously, there is already some case law from the Human Rights Committee in the Saki case, in which the committee actually declared those complaints, those applications inadmissible for non-exhaustion of domestic remedies with respect to the several countries that were against which the cases were brought. The case of Duarte also will raise the question of extraterritoriality. Obviously, all of them concern responsibility attribution and material causality. The attribution of responsibility to individual states, I suppose, now has been also resolved to a certain effect by the case law, and this is what Lucy said in her presentation, that it was the argument that the shared that certain countries may only contribute to greenhouse gas emissions in a small portion did not stand before the national courts, but however for our court, another aspect of material causality is actually to which extent the triggering event, so a wildfire, a drought, a heat wave, affects the applicant's human rights guaranteed by the convention. And this takes me to the requirement of severity of human rights impact. So the court has extensive case law on the environment, really. We have decided more than 300 cases which had environmental elements. But the court has always said, and this is a foundational principle, that the impact on human rights has to be severe. So we're not going to deal with just any environmental degradation or any environmental harm. It has to meet a severity threshold to meet the applicability test for certain rights. And then lastly, what I want to mention is that in all of these cases, potentially the court or the judges of the court may want to engage with what is the right to a healthy environment. And just to give you the brand new development from the court, are two Russian cases decided in September of this year, already available on our HUDOC, our database. Kotov and Pavlov cases. They are classical pollution cases, if you wish, stemming from a situation of extensive pollution coming from a landfill and also a factory in Russia. But the original aspect of these cases is that that one of the judges in his concurring opinion, violations were obviously found in these cases, but because of the massiveness and the real severity of pollution. But one of the judges from Cyprus, Judge Sergides, wrote in his concurring opinion how, in his view, nowadays, actually through its case law, the court has already recognized the right to a healthy environment stemming from Article 8, so the right to a private life, so that this is already a fact in our case law, even though the court in its judgments, actually in the operative part, has never really said that. The Judge Sergides argues that the anthropocentric dimension of the right has been already recognized. However, he goes further and he encourages the recognition or the adoption of a separate protocol in order to bring a self-standing right to a healthy environment that would contain also its ecocentric dimension. So this is an interesting development, and we'll see whether the judges of the Grand Chamber are going to take issue with that, whether they're going to develop that argument or not. Now, just to finish off, we have, like I said, the relevant case law. This may be viewed as both an obstacle and a potential gate that is opening, but this is in any event the basis with which our judges of Grand Chamber are going to work with. So I told you that we already have we have dealt with the notion of direct victim, and we have also dealt in our case law with the notion of potential victim. There are two approaches that are present in our case law to the concept of potential victim. The first one is more similar to the Neubauer's approach, I suppose, the Constitutional Court of Karlsruhe, whereas a potential victim is defined in reference to a law that exists. The court will look at whether or not an applicant is facing a situation in which he or she has to modify his conduct at risk of being directly affected by legislation. So this is what we have had in cases where people were under surveillance, or people could not have access to equal sex marriage, or people were facing with fines for wearing burqa. So for full face covering in public, because the laws in those states were such as they were forbidding such conduct. Another approach is more on a fact basis. So a potential victim is a person who can prove that there are substantial grounds for believing that the person would face real risk. And we have dealt with cases of deportation, of migration, of refugees. So the material that we are familiar with is that the risk of being subjected to torture, to persecution. But this will apply also to the climate cases in which the people may, or the argument is that potentially, yes, it's already proved by science that the future impacts of climate change, meaning extreme weather events, will really happen. So the test in environmental cases is that the risk has to be imminent. So again, the question is how the judges of the Grand Chamber are going to define the imminent aspect of the coming risk. We'll see. Obviously, they will also be able to look at the Daniel Billy case, the Torres Strait Islanders case, the Saki case, the previous case of Teitiota, the national judgments. So there is material to work with. Material causality will be another core issue for the court, and I'm not going to explain all of this that you see on the screen here. Again, a direct and immediate link must be established, but then the court has already started relaxing this test, and we have already pronouncements from our case law in which sufficiently close link was accepted by the court. Whether this is causality on the basis of probabilities, I don't know. We'll have to see whether the court confirms it. I'm sorry about the noise. And then what I do want to stress is that what is necessary to prove by the applicants is either a specific impact on health of these people, or on general health vulnerability, or on well-being, on quality of private life. So it's not necessary to actually come to the European Court with a medical certificate which will prove that somebody is already attained or is suffering from a particular ailment. It's enough to show that the general health has been made vulnerable, or that simply the quality of life has dropped because of those impacts of climate change. And the last main issue, not really last, but the last that I'm mentioning here, is the question of extraterritoriality. And the court has also developed this notion through cases concerning internal conflict or international conflict. And we have already recognized the spatial concept of jurisdiction, which means that a state would have effective control over territory of a foreign state, which is not bound by the European Convention. And this extends the member states' responsibility for human rights violations. And we have also recognized the personal concept of jurisdiction, in which the effective control is over a person who is being captured by the agents of the state. And the recent development, which is important and which is interesting for the purpose of climate litigation potentially, is that recently in a case against Russia and the interstate case, the court has recognized or accepted the test of specific act involving an element of proximity. So it's not an effective control over territory. It's not really a physical control over the person because there is no contact, but still exposing a person, for example, to a chemical gas, poisonous gas, was accepted to fall within the jurisdiction of the court. Further developments are happening by means of interstate cases, and we will see then whether the court gets to the extraterritoriality based on cause and effect, which was already set out in the advisory opinion of the Inter-American Court of Human Rights in 2017, and then confirmed by the Saki case decided by the Human Rights Committee. So we have the case law of the court, and we have the case law and the developments from other jurisdictions. I want to end by saying that the court does not interpret the European Convention on Human Rights in a vacuum. It is both a living instrument, and it has to be both decided on the basis of the dynamic principle of the living instrument, but also in harmony with the international corpus juris. So the court will certainly, and you could see it already through the questions that were asked when the climate cases were communicated, and now it's also, I can tell you that the court in the Grand Chamber questions has also referred to both the Paris Agreement, United Nations Framework Convention on Climate Change, and to certain judgments from national jurisdictions. So the court is very much aware and is looking at what has happened and what is happening in terms of international legal framework that also contains those national decisions and international decisions of international human rights bodies, in order to help it to define the existing notions and to see how far we can go. I encourage all of you now to
Natalia, I'm sorry, I will need to interrupt you. Can you hear me? Just because we have exhausted at the time of our panel.
Yes. No, I'm done. Really, just leaving you with the knowledge sharing website that we now made public, so you can see the guide on environmental human rights. And thank you very much for your attention.
No, it was, we didn't want to interrupt because it was very, very interesting to hear your analysis. So thank you very much. Because of the time, unfortunately, we won't be able to take questions, but I would like just to, again, thank all the panelists, thank my co-chair, Maria Antonia, thank the organizers of the Climate Law and Governance Day. Thank you, Lucy Maxwell, Cesar Garavito, Justice Barroso. It's a pleasure to have you with us as well, and Natalia. So I would like to say that this has been a very, very insightful discussion. I think we need this panel at every Climate Law and Governance Day, because every year there are major developments going on with the human rights-based climate cases. And I wish the best of luck to all the litigants in these cases. And I also would like to congratulate Justice Barroso and also the other judges that have been ruling on these cases and advancing the human rights law to protect the climate. So thank you very much. And I hope you all enjoy the rest of the event.